It's one and the same person, the lawyer. So the lawyer gets to be, quote, the fox guarding the hen house, but they're both the fox and the hen, and they can do whatever they want. Hi, Jeff Marsace, the Plain English Attorney, and welcome to the video. And today we're going to talk about a pretty disturbing topic about how some attorneys can simply set themselves up to make a whole bunch of money in the future when they're doing a revocable living trust. Now, unfortunately, this is an instance that's come up again. I did a video a while back about how a law firm set itself up for their clients to basically be their ATM, and I thought things had changed based on other trusts I've reviewed, but I guess it hasn't. It has come back. So this is all done under the guise of protecting the estate and making sure that things don't go wrong, and, well, things could change. But the attorney's the one interjecting themselves. So let me go ahead and let's kind of jump into the discussion and some of the different provisions and terms that I recently reviewed in this trust. Now, the protective trust provision, well, all right, you have trustees that are named. And for a lot of my clients who are older and they've got adult children that they trust, they could name their kids in succession. Let's just say there's 3 kids in succession, or, let's keep it simple. We're going to do 2 children in succession as the trustee. Okay? Well, that's fine. There's nothing wrong with that. I would look for a third, but not a law firm. I do everything that I can to not be named as a trustee in a trust because it has conflicts of interest kind of involved there. Nobody really likes the attorney that's telling them, no, you can't, and they have authority. And it always looks, no matter what, it always looks like the attorney talked the client into making them the trustee.
If you think it's important for educational videos like this to get out there, then please help us out by subscribing to the channel.
Now, I know that there are some, it's easier to settle, and yeah, there are some arguments for that, but often it's better just to have, say, an independent trust company handle that if they don't want to put the burden on family, friends, and the other people that they trust in their life. But you have the trustees set up. Well, what are some of the other, quote, protective trust provisions that I saw inside this trust that I reviewed? It's a position called the trust advisor. All right, sounds a little innocuous, but it's not. The trust advisor is allowed to remove the trustee for no reason whatsoever. There isn't any kind of standard. They can just remove the trustee. All right, that in itself isn't necessarily a bad thing. I use a provision that's called a trust protector. And that has very different meanings depending on the drafting attorney and what's common in the state. For what I use it for is simply to remove a trustee if there's some kind of wrongdoing. And then it falls to the next trustee in line. So it's already set. That's it. Another typical power of a trust protector that I'm not really using just because I kind of make the trust as flexible as possible so it's not needed. They can, quote, change and amend the language of the trust to comply with the intention of the person who created the trust. All right. That particular type of clause is often has some disclaimer language that if tax situations change, then they're allowed to go in and make those changes and adjust it to comply with whatever the updated language is. Not a problem there. So let's go on to some of the other things with the trust advisor. This one was actually the most disturbing piece of it with the trust advisor, is if there was a vacancy in the trusteeship, meaning there are no more trustees, then the trust advisor appoints the trustee. So they could eliminate the two kids and say, no, I'm just removing you as the trustee, and I don't have to give a reason, and I'm going to appoint the new one. Well, who are they going to appoint? In this document, the lawyer named themselves as the trust advisor, and they're allowed to name themselves to take over as trustee. Okay, so they could just throw out all your choices and put in whomever they wanted. That's where it starts to really get disturbing. But part of that is right under that clause in the trust. There's a waiver of a conflict of interest, so that when the client is actually signing their trust document, they're waiving the conflict of interest, specifically pointing out that the trust advisor could name themselves to be the trustee who's overseeing things. So the trustee's running everything, but them as the trust advisor, they're making sure that the trustee is doing what they need to do. It's one and the same person. The lawyer. So the lawyer gets to be, quote, the fox guarding the hen house, but they're both the fox and the hen, and they can do whatever they want. So that's pretty disturbing, because now, not only that, the lawyer gets paid for both of those roles. Well, who gets to object to their fees? Well, I suppose the beneficiaries could, but the lawyer now is drawing two paychecks, and as long as they don't make it ridiculous, it's complying with the terms of the trust. All right, so what else is going on here? An independent special trustee could be established to oversee assets that, for whatever reason, the trustee doesn't want to handle. So this could be they're appointing an independent trustee to manage, say, a rental property separately from the trustee, and empower them just by writing out, here's what I want to empower you to do. And they can name a member of their law firm, another attorney, who now is also, now that's 3 paychecks they could be drawing. All right. Can it get any worse? Yeah, it can. Legal counsel. They can hire attorneys to assist them. And it could be from their own firm. So now you've got those 3 positions, but that could end up being 6 paychecks coming out of the trust. Now, what I would hear and expect to hear is, oh God, you're setting up this scenario. We would never do that. Yeah, well, sometimes when people are desperate for money, they do stupid things. And because the terms of the trust allow it, and there's this waivers of conflict of interest and all this other stuff, it's just opening the door for this trust to be used as an ATM tied to an account that's someone else's money. And they could get away with it. It's very disturbing to have this type of language. Ugh, that's horrible. Can it get any worse? Yeah, it can. Because now they can change beneficiary ages of inheritance. So, Let's review. If you have two adult children, say they're 40 and 43, and in the trust it states that they would receive their inheritance at age 40. And the attorney may even say, look, this is if something happens to one of your kids and it's going to the grandkids, there's an age limit of 40 and it's flexible. The trustee could always give the money early. And honestly, that's the age that most of my clients pick and why we do it, so they can judge maturity and provide the inheritance early if it's okay. But if it's not, they can hold it till 40. Well, now this trust advisor has the power to say, no, you don't get anything unless the trustee gives it to you until age 100. There's no guidelines. They can make it whatever they want. And now suddenly, if that person died, that younger of the two kids is age 40, they could hold on to that trust and drain that money for the next 60 years. Well, what if they die? Well, now it's the grandkids' money. They can keep increasing, or say you don't get it until you're 100. And now that law firm and that attorney can keep taking that money in their fees as pay for doing their job and overseeing the trust for as long as they want. So this is really some dangerous language to have inside a trust. When I'm recording this, we just recently had the elections. I want you to imagine this. They're trying to do election reform, and a former governor is being put at the head of a commission to come up with a way to administer the elections in a way that is more secure and fair. And what they said is, all right, so we need to write into the law that we need to have an election protector. Well, who's that? Well, I am. This former governor. They're the ones in charge. Okay, well, what powers does this election protector have? Well, if they think subjectively, not based on any standard, that the election was stolen, and they can just simply pull the person out who won and say, you didn't win. And do that to the next person with the next number of votes and the next person. Well, what happens then if there's a vacancy? Oh, well, the governor can name someone to take that position. So someone who wasn't elected at all gets to take that position. Yeah, who? Well, the governor can appoint themselves. So now they can make themselves the new governor or U.S. senator. And there's no conflict of interest because the law says there's no conflict of interest. And on top of that, they're allowed, in this new law they're proposing, they can extend the term for that governor to be governor that they named themselves into. They can extend the time period for as long as they want. So they could be governor for life. All they have to do is just kind of wave their magic wand and it's done. That doesn't sound very fair. There are no checks and balances there. And it just ends up being the potential to be a corruption machine. That's what we have when an attorney can name themselves as that trust advisor. They can remove the trustee for any reason at all, name themselves as the trustee. They've got a waiver of a conflict of interest. We have the ability to hire. It's just they can take as much money as they want and justify it, and they've written it into the trust. I've got a problem with that, and I think my clients, whom I'm going to be reporting this to, I think they would have a big problem with this as well. So, yes, I'm a little animated about this because I don't like the fact that some attorneys are really taking advantage of their clients, even potentially. And even if they'll say, oh, we would never do that, we would never do that. I don't trust that. So, please, if you're going to be working with an attorney and you're going to see the kind of language that's in there, check it out to make sure that they're not writing themselves in to be able to do whatever they want. Like I said, when we use a trust protector language, yeah, I'm naming me, but it's to remove the trustee and it goes to the next one. And I've never been called on to actually do that. Other than that, it really does smell of corruption. So I hope you found that information useful. If you're putting together a plan, look for some of these things. You want the people that you want in charge, not who the lawyer wants in charge. So as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.